Hello, my dear students. Today I have selected a topic rules regarding separate or self acquired property under the Hindu Succession Act 1956. Sections 8 to 13 deals with this topic. The Hindu Succession Act 1956 amended in 2005. It received the assent from the President of India on 5th September 2005 and it came into force on 9th September 2005. Why this amendment was made? What is the necessity behind it? It was essentially meant for removing gender discriminative provisions regarding property rights in the Hindu Succession Act 1956. So, if you read the 1956 Act, that is before the amendment 2005, you will find a lot of gender discriminative provisions with respect to the property. So, with an intent to remove these gender discriminative provisions under the Hindu Succession Act, particularly with respect to the property rights of a woman, an amendment was made in 2005. So, it was a revolutionary step in the field of Indian legislation regarding property rights of a woman in India. You all know that criminal law, that is Indian Penal Code or Criminal Procedure Code or Civil Procedure Code, Constitutional Law, Administrative Law, Transfer of Property Act, any law is equally applicable to all Indian citizens, irrespective of their religion, race, caste, place of birth, etc. It is applicable to all Indian citizens. But when you come to the family matters, particularly marriage, divorce, custody of the children, adoption, maintenance, property, etc., they are to be governed by their own laws. Each religion has their own laws. Hindus are to be governed by the Hindu laws. Muslims are to be governed by the Muslim laws. Christians are to be governed by the Christian laws, and Parsis are also to be governed by their own laws, Parsi law. So, similarly, here the property rights, Hindu Succession Act 1956 is applicable only to the Hindus. For Muslims, they have the Muslim law of succession. Christians and Parsis are in India, they are governed by the Indian Succession Act 1925. Hindu Succession Act, succession. What is a succession? Succession is of two types. One is testamentary succession and the other is interstate succession. What is a testamentary succession? If the property is distributed through will, it is a testamentary succession. That is, the testamentary document establishes the intent and wish of a person who wants to give his or her property to certain people. That is, for example, X having a property. He intended or wished to give his property equally among Y and Z. So he exhibits his intent and wish in the will. He writes the will that his property is to be distributed among Y and Z equally. So it was his intention, his wish was expressed through making a will, and the property will be given to Y and Z. On his death, after his death, according to the will, the property will be given equally to the Y and Z. The problem doesn't arise. Whether they are eligible or not also doesn't arise because he intended to give his property to Y and Z, so he gave. Interstate succession, second. If the person dies without making a will, it is interstate succession. A person who dies without making a will, that is X having the property and he did not make a will. He dies, he had a property. To whom it has to be given? Who are the heirs? That is to be determined by interstate, that is interstate succession. So testamentary succession, interstate succession. If you have disposed of his property through a will, it is a testamentary succession, and if he dies without making a will, it is an interstate succession. So now let us come to the interstate succession. According to section 8 to 13, it deals with the male Hindu separate property. What is required? He must be a Hindu. We said that Hindu Succession Act is to be governed, applicable only to the Hindus. male. For female, this 8 to 13 is not applicable, because suppose if the female having the property, his property will be distributed according to section 15 and 16 of the Hindu Succession Act. It is applicable only to the male. So what is first condition? He must be a male Hindu and having a separate or self-acquired property. Dies without making a will. Dies intestate, that is without making a will. A Hindu male having a separate or self-acquired property dies intestate, that is without making a will. Then this section 8 to 13 determines who are the heirs, what are the order of succession, and what are the share values. For the application of this law of inheritance, that is 8 to 13, 8 to 13 is applicable or applied only in the first and foremost condition is that the property of the deceased should not have been disposed of a will. Only in the absence of the will, a person who dies without making the will, then this law of inheritance or interstate succession or section 8 to 13 are applicable. So a Hindu male having a separate or self-acquired property. What's the separate or self-acquired property? What type of property will be considered as a separate or self-acquired property? Under Hindu law, two properties are to be considered. One is ancestral property and the other is separate property. Ancestral property. What is an ancestral property? Ancestral property is the one property inherited from father, father's father, father's father's father, father's father's father, and so on. Paternal grandparent. Paternal grandparent. That is ancestral property. Property inherited from great grandfathers on the paternal side. Then section 6 is applicable there. Section 6 is applicable. Ancestral property, section 6 deals with it. Separate property, section 8 to 13. What type of property is a separate property? Salary, shares in the profits, received any property through will or a gift, or inherited property from any relative other than the paternal grandparents. In the maternal grandparents, suppose if the person inherited property from the maternal grandparents or the maternal grandmothers or the paternal grandmother or any aunt, uncles, on either paternal or maternal, whatever it may be, from inherited property from any relative, received any property by way of prizes or the lotteries. These are considered as separate or self-acquired property. Salary, shares in the profit, received through a will or gift, inheritance from any relative, received by way of prizes or a lottery. Even copacenary is empowered to hold a separate property. He will inherit some property from the paternal grandparents, and he will also earn his own money, separate property. So here for the ancestral property, section 6 is applicable, and for separate property, section 8 to 13 is applicable. When this act will commence? When this will come into operation? Section 8 to 13, when it will come into operation? Generally, the Hindu Succession Act came into force from 17th June 1956. From 17th June 1956, this act has came into operation. So the death of a male Hindu need not be after the commencement of the act. That is, the death of a male need not be after 17th June 1956, which means a Hindu male may die even before the 17th June 1956 or may die after 17th June 1956. Whether he died before or after is irrelevant. The death of a male Hindu is not necessary. He may die even before or after. It is not a problem. The here required is section 8 applies only where the succession opens after the commencement of the act. That is, the succession must opens after 17th June 1956. Then only section 8 is applicable. If the succession opens 16th June 1956, one day before 16th June 1956, section 8 is not applicable. So the succession must opens after the commencement of the act, after 17th June 1956, then only section 8 is applicable. For example, a Hindu male settles his property to his wife for her life. And after her death, the property would be held by his daughter for her life. The Hindu male dies in 1933 and wife dies in 1945. But the daughter dies after the commencement of the act. That is, the daughter dies after 17th June 1956. On the death of the daughter, the succession opens. That is, the succession also opens after the commencement because the daughter dies after the 17th June 1956. So the succession opens after 17th June 1956. Section 8 will be applicable even though the Hindu male dies before the commencement of the act. Similarly, where the owner of a self-acquired property dies during the pendency of a suit involving the property. So there was some dispute was there with respect to the property and the case was pending before the court and the person dies during the pendency of that suit. The case was not settled. It was in pendency of the suit. During the pendency of the suit, the person dies. Then the succession to the property will be according to Section 8 of the Hindu Succession Act 19. That is, Section 8 will be applicable. Section 8 will be applicable. According to Section 8, the property will be distributed. See some of the heirs. So definitions. Heir. Any person. Now let us see some of the definitions. Important definitions. First, heir. Who is a heir? Any person, male or female, who is entitled to succeed to the property of an intestate under this act. Any person who is entitled to succeed to the property of the intestate, whether male or female, they are considered as a heir. Intestate, we have already discussed a person who dies without making a will. So a person is deemed to be die intestate in respect of the property of which he or she has not made, this is very important, has not made a testamentary disposition capable of taking effect. So he is not making any will. Without making a will, he dies. Agnate. One person is said to be agnate of another. That is X and Y. There are two persons, X and Y. One person is said to be agnate of another. X is an agnate to Y. Y is an agnate to X. How you will say Y is an agnate to X. Both X and Y are related by blood or by adoption wholly through the males. So two conditions. One is the relation between the X and Y or either by blood or by adoption. Second is the relation between the X and Y are wholly through the male. That is sons, 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 sons. So all are male only between X and Y. All are male. So two conditions are required. One is the relation between the X and Y are by blood or adoption, and second is they are wholly related through male. Cognate. This is also same, almost very slight difference. One person is said to cognate of another. Y is cognate to X when both are related either by blood or adoption. First condition is the same. Second is not wholly through male. That is some female hair has intervened. That is son, son's daughter. So son's daughter is a female. Son, son's daughter, son's daughter's son, son's daughter's son's daughter. Maybe a male or female at the end. Both in the agnate and cognate, at the end they may be male or female. That is the third condition. Section 8. The property of a Hindu male dying intestate or without a will would be given first to the class 1 heirs. The property will be first given to the class 1 heirs. If all the heirs in the class 1 are absent, then the property shall be given to the class 2 heirs. If all the heirs in the class 1 and class 2 are absent, then the property shall be given to the agnates. If all the class 1, class 2 and agnate are absent, all the heirs are absent, then the property shall be given to the cognate. So class 1 first, in the absence of class 1, class 2. If there are no class 1 and class 2 heirs, agnates. And if there are no class 1, class 2 and agnate, then the property shall be given to the cognates. Class 1 heirs. So up to 2005, there are only 12 heirs in the class 1. There are only total 12 heirs in class 1. They are son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter, daughter of a predeceased daughter, widow of a predeceased son, son of a predeceased son of a predeceased son, daughter of a predeceased son of a predeceased son, widow of a predeceased son of a predeceased son. So 12 heirs are included in the class 1 heirs before 2005. So after the Amendment Act 2005, four more heirs were added to the list of class 1 heirs. Four more heirs were added. That is 12 plus 4 is equal to, now at present there are total 16 heirs. There are total 16 heirs are there in the class 1 heirs. Actually these four heirs are not new heirs. Before 2005 Act, all these four heirs are in the class 2 heirs. They are in class 2 heirs. Now they are transferred or shifted from class 2 to the class 1 heir after 2005. So these four heirs were added in the schedule to the Principal Act under the subheading class 1 after the words widow of a predeceased son of a predeceased son, the words. The four heirs, who are the four heirs that are included in the class 1 from class 2? Son of a predeceased daughter of a predeceased daughter, that is daughter's son, daughter of a predeceased daughter of a predeceased daughter, daughter's daughter, daughter of a predeceased son of a predeceased daughter, daughter's son's daughter, daughter of a predeceased daughter of a predeceased son, son's daughter's daughter. So daughter's son, daughter's daughter, daughter's son's daughter, and son's daughter's daughters. These four heirs are shifted from class 2 to the class 1, and now these four are added to the class 1 heirs, and now there are total 16. So look into this table. This is an interstate Hindu male died without making a will. So his heirs according to section 8, mother, widow, surviving son, surviving daughter, and predeceased son, son's son, son's daughter, son's widow, son's daughter's daughter, daughter's daughter, daughter's son, daughter's son's daughter, son's son's son, son's son's daughter, son's son's widow, daughter's daughter, daughter's son. So the total 16 heirs. So those are in the red letters. Son's daughter's daughter, daughter's son's daughter, daughter's daughter, daughter's son are shifted from class 2 to the class 1 heirs in 2005 Amendment Act. First, mother. Mother includes biological as well as adoptive mother. Biological as well as adoptive mother. That is natural mother and adoptive mother. They are entitled to take a share from the son's property. Adoptive mother can inherit from son's property. An adoptive mother may be an unmarried widow or a divorce, because according to Adoption and Maintenance Act, only unmarried widow and divorced women are entitled to adopt a child. If the husband is there, only husband is right to take adopt a child, but consent of the wife is required. But even with the consent of the husband, the woman is not entitled to adopt a child. So only unmarried, widow and divorced women are entitled to adopt a child. So an adoptive mother can inherit a property from her son's property. So it includes both natural as well as adoptive mother. But stepmother is not included. Stepmother is not entitled to take a share from stepson's property. So stepmother is not included. She is not entitled to claim any share in the stepson's property. Marital status of the mother is irrelevant. Whether the mother is a married or unmarried, she is entitled to take a share from son's property. That is, at the time of the birth of the son, whether the mother is a married or unmarried is irrelevant. Is irrelevant. That is, an unwed mother also inherits from her son. Similarly, legitimate or illegitimate does not affect the inheritance rights of the mother. That is, the mother is entitled to take a share even from the illegitimate son's property. whether the son is a legitimate or illegitimate. The mother is entitled to take a share from son's property. Conduct of the mother is irrelevant, whether she's a good or bad. Whatever the type of conduct she had, she is entitled to take a share from her son's property. She may be involved in living relationship with father or any other person. She can remarry somebody other than the father of the child. She can remarry any other person other than the father of the child. Even if she renounces Hindu religion and converts to some other religion, whether a Christian, Muslim, whatever the religion she is converted, she is entitled to inherit the property. So, natural adoptive mother entitled to take a share, and whether she is married or unmarried, unwed mother is also entitled, whether the son is a legitimate or illegitimate, what type of conduct she had, whether she involved in the living relationship, or whether she renounces Hindu religion, convert to some other religion, or even if she remarry any other person, she mother is entitled to take a share from her son's property. Next video. The word wife refers to the spouse of a valid marriage. First, there must be a valid marriage between them. Then only she is to be considered as a wife, and the wife is entitled to take a share from her husband's property. A woman who was a party to a void or voidable marriage, and that marriage was annulled by a decree of nullity. So now she is no more a wife to the person. So on the death of the man, she is not a wife. She is not to be considered as a widow, so she is not entitled to take a share in his property. Thus, even the second wife, party to a bigamous marriage or a void marriage, is not a widow, so she is not competent to inherit his property. In case of voidable marriage, since the marriage is valid till the annulled by the court. In all cases of voidable marriages, the marriage is to be considered as a valid till it is annulled by the court. So, suppose if the person dies before the court issue a decree of nullity of the marriage, then wife would be entitled to inherit the property because the court has not annulled the marriage. So, voidable marriage is to be considered as a valid marriage, so she is considered a wife, so she is entitled to take a share from her husband's property. Woman living with a man without getting married to him would not succeed to the property. But contrary has taken by some of the courts because living relationship is to be considered as a wife and husband. Suppose if we live in a long period and the society is also considered them as a wife and husband, there are some cases are there where the court in some cases contrary has been taken, but generally women living with a man without getting married to him would not succeed to the property. A Hindu male married a Christian woman or any Muslim woman, they are not entitled to claim a share in his property. The widow does not include a divorced wife. Once a divorce has been declared, there is no relation between the husband and wife. She is not be considered as a wife. When she is not considered as a wife, on the death of the person, she is not a widow, so she is not entitled to take a share from his property. But it includes a wife who, at the time of the death of the male Hindu, was living separately under the decree of judicial separation. Now, both husband and wife are living separately under the decree of judicial separation, and the case was still pending. The court has not declared divorce. At that moment, the Hindu male died. Still, the woman is to be considered as a wife, and she is a widow, so she is entitled to take a share from his property. The moral character or faithfulness are not relevant for determining the eligibility to claim property. But contrary is also taken by some of the courts. Son. Son includes natural as well as adopted son, but does not include stepson or an illegitimate son. The son born void or voidable marriages is a legitimate child. So, since it is a legitimate child, he is entitled to take a share from his father's property. Son cannot claim right by birth in it. It is only in the ancestral property where the son can claim by birth in it. But now it is a separate or self-acquired property. Son cannot claim a right by birth in it. The expression son does not include a grandson, but includes a posthumous child. Posthumous child is child in the womb. A child in the womb has also the right to inherit the property. So son includes the posthumous son, but not the grandson. And similarly, the defective marriages, casual or occasional relationship is to be treated as an illegitimate, so they are ineligible to take the property. But the contrary view has also been taken in certain categories. Daughter. Daughter includes natural as well as adopted daughter, but does not include a stepdaughter or an illegitimate daughter. The daughter born void or voidable marriages is a legitimate child, so she is entitled to claim a share from her father's property. Both married as well as unmarried daughter can inherit the father's property. Whether she's a married or unmarried is not relevant. Whether she's a married or unmarried, she's entitled to take a share from her father's property. Marital status, that is married or unmarried, is not relevant. Her chastity is not relevant. Her financial position is not relevant. So a wealthy daughter will inherit a share equal to that of a poor son. She's a very rich, the daughter is very rich, the son is very poor, but still both will take equal shares. How and to whom she gets married is totally relevant. How she is married, to whom she married, whether it is intercaste marriage or to whom she married already a married person, is are all irrelevant. She is entitled to take a share from her father's property. A daughter might be involved in a living relationship with a man or may have an affair with a married man. They are not disqualifications. Still, she is entitled to take a share from her father's property. For whether she's a married or unmarried, whatever the marital status, whatever her chastity, whatever may the financial position, whom she get married, how she get married, or a daughter, whether she involved in a living relationship or had an affair with a married man, these are all not a disqualifications to the daughter, and daughter is entitled to take a share from her father's property. Section 9 deals with the order of succession. Among the heirs, there are how many heirs? 16 heirs. 16 heirs are specified in the schedule. Those in the class 1, that is all the 16 heirs, take simultaneous and equally by excluding the exclusion of all other heirs, that is exclusion of class 2 agnates and cognates. So all the heirs, that is 16 heirs are there, they will take simultaneously and equally to the exclusion of all other heirs. Section 9 says very simple, all will take simultaneously and equally. Section 10 says distribution of the property among the heirs in class 1 of the schedule. How property will be distributed? The property of an interstate shall be divided among the heirs in class 1 of the schedule according to the four rules. Rule 1, interstate's widow, or if whether the interstate had a single widow or more than one widow, they will be allotted only one share. One share will be allotted. If there is one wife, that two share will be taken by that widow. Suppose if there are three widows, this one share will be equally distributed among the three heirs. So only one share will be allotted to the widow. Rule 2 says the surviving sons and daughters and the mother of the intestate shall each take one share. The surviving sons and daughters and mother all will take each share. Suppose there is one son, daughter, and three, each will get one share, three shares. Suppose if there are two sons, two daughters, and mother, five shares. Out of each one will get one share. So rule 1 speaks about the widow of the intestate. Rule 2 speaks about the mother and surviving sons and daughters. And rule 3 speaks about the branch of the predeceased son or the branch of a predeceased daughter of the intestate. They also take one share each. Rule 4 says the distribution of the share of branches, the predeceased son, to their heirs equally and simultaneously. Similarly, the branch of a predeceased daughter's share will be distributed equally among their heirs. Now, by seeing certain illustrations, you can understand how the property will be distributed. Here, example, the deceased having a mother, wife, son, and daughter. So, according to rule 1, the widow will get one share. According to rule 2, mother and surviving sons and daughter will get each one share. So, how many heirs? Mother, widow, son, and daughter. There are four heirs. According to section 9, all the heirs will take simultaneously and equally. And according to rule 1 and rule 2 of section 10, each will take one share. So the whole property, one property is to be divided into four portions, four equal portions. So each will get 1 by 4th. That mother will get 1 by 4th, wife, widow will get 1 by 4th, and son will get 1 by 4th, daughter will get 1 by 4th. The other illustration, where the deceased has a mother, two wives. Here in the first illustration, only one wife, so one share has been given. The whole property will, that one share will be taken by that widow. But here there are two widows, two sons, surviving sons, and two surviving daughters. So how many heirs are there? Mother, widow, son, S1, S2, D1, and D2. So there are total 6 heirs. So the property is to be divided into equally into 6 portions. So mother will get 1 by 6, widows will get 1 by 6, S1 will get 1 by 6, S2 will get 1 by 6, D1 will get 1 by 6, D2 will get 1 by 6. And the 1 by 6 that is allotted to the widows, there are two widows. That is to be again distributed equally between them. That is 1 by 6 into 1 by 2. That is 1 by 12. W1 will get 1 by 12 and W2 will get 1 by 2. W1 will get 1 by 12, W2 get 1 by 12, and rest M mother S1, S2, D1, D2 all will get 1 by 6 each. And here this is the one illustration, all the 16 heirs are there, and where it is to be distributed according to rule 1, rule 2, rule 3 and rule 4. All the 4 rules are included in this one. A deceased having a mother, widow, S1 surviving son, D1 surviving daughter, S2 predeceased son, D2 predeceased daughter. So S2 is the one branch and D2 is another branch. And how many heirs are there? Mother, widow, S1, D1, S2, D2. Total 6. So the property is to be divided equally into 6 portions. So mother will get 1 by 6, widow will get 1 by 6, S1 will get 1 by 6, D1 will get 1 by 6, S2 will get 1 by 6, and D2 will get 1 by 6. This is according to rule 1, rule 2, rule 3. So according to rule 1, widow will get 1 share, 1 by 6. According to rule 2, mother and surviving son and daughters, that is mother, S1 and D1, will get 1 share. And according to rule 3, the branches of predeceased son, S2, and branches of a predeceased daughter also will take 1 share. So total, according to rule 1, rule 2 and rule 3, 1 by 6, 1 by 6 is allotted to all the heirs. Now rule 4 says, the share that is allotted to the branch of a predeceased daughter, D2, is to be equally divided among his daughter's daughter and daughter's son. That is 1 by 6 is because D2 has a 2 heirs, daughter's daughter and daughter's son. So it is to be equally distributed among them. So 1 by 6 is to be divided into 2 portions. 1 by 6 into half 1 by 2 is equal to 1 by 12, 1 by 12. So DD, daughter's daughter, daughter's son, in the branch of D2 will get 1 by 12, 1 by 12. Now come to the S2, predeceased son's branch. First 1 by 6 is to be divided among his heirs, son's widow, son's son, son's daughter, and son's son's SS1. That is predeceased son. So 1 by 6 is to be divided equally among 4 heirs. That is son's widow, son's son, son's daughter, that is SW, SS, SD, SS1. 1 by 6 into 1 by 4 is equal to 1 by 24. So SW will get 1 by 24, SS will get 1 by 24, SD will get 1 by 24, and SS1 will get 1 by 24. And this 1 by 24 of SS1 will be divided equally between SSW, SSS, SSSD. That is 1 by 24 into 1 by 3 is equal to 1 by 72. Other illustration. The deceased having a wife and the wife had a son, DS1. The marriage between the W and deceased is a valid marriage. But she is a concubine to the deceased and DS2 is the son of a concubine. So concubine is not a wife, so she is not entitled to inherit the property. And similarly, the DS2 is a legitimate son, so he is also not entitled to take a share from the deceased's property. And it is only the wife and DS1, they will take equally. That is half will taken by the W and DS1, and S and DS2 will get nothing. The other illustration, the deceased having a son's widow, only one heir in the class 1 heir. Son's widow and father. Son's widow is a class 1 heir. Father is a class 2 heir. So, in the presence of the class 1 heir, class 2 heir will not get anything. So, SSW is a class 1 heir. So, father is a class 2 heir. So, father will not get anything because class 1 heir was there, SSW. So, the whole the property will be taken by SSW and father will not get anything. So, this is the few illustration how the property will be distributed among the class 1 heirs of the interstate under the Hindu Succession Act 1956. So in the next video, we'll start the class 2 heirs and agnates and cognates.